I only have an hour, so I have 80 slides, so I'm going to go through some of this rather quickly, but there's a lot of aspects of healthcare reform that apply to small employers. And that's the purpose behind this presentation, to kind of give you a clue, if you're a small employer, what you're going to be facing. Here are all the different things that apply to small employers. Some I'm just going to breeze through, maybe point out so you can read it later. Other situations I'm going to hit it much harder because I see this day to day. In my practice as an attorney, I get anywhere from 100 to 200 questions from various types of employers, both large and small. Healthcare reform is extremely complicated, convoluted, and because of that, it hits all these different areas, and you have to be aware of the fact where you have to comply. Now, what's also very interesting, there is various definitions of a small employer, which makes it rather complicated. For the employer mandate, it's going to be anyone who's under 100, only if certain transitional rules apply. So if you're under 100 between 50 to 99, there's a transitional rule that will apply, so the employer mandate doesn't kick in until 2016. All right? Then it jumps down to 50 in 2016 for the mandate. Rules, it's going to be 50 in 2015, then it comes to 100 for 2016 and after, and then for the small employer tax credit, it's only 25 employees. So dealing in certain aspects of healthcare reform, the definition changes, and there's all kinds of aspects of this, and I'll give you a couple examples. In regard to a full-time employee, if you're determining if you're a large employer, a full-time employee is defined as 120 hours, but for coverage is defined as 130 hours. It confuses people. There's another definition called seasonal worker. A seasonal worker is someone that works for you for 120 days a year, while seasonal employee is somebody who works for you 6 months. So that's what confuses people, because there's various definitions as this for various purposes. So it really confuses people. What applies to small employers, and I've covered this before, but I just want to briefly indicate the fact that these fees and taxes apply to all employers. First, the PCOR fee, which has been around for a while. It's to fund a not-for-profit corporation called the Patient-Centered Outcomes Research Institute. We call this the PCOR fee. This fee only applies what we call exempted benefits, which do not apply to exempted benefits, which are basically dental, vision, and preventive care, and also supplemental benefits. It first came into play in 2000 for plan years after 2012. It's going to go away in 2019. Now, if you're insured, don't worry, the insurance companies will pay the PCOR fee and pass the cost on to you. If you're self-insured, basically what you have to do, you basically have to pay the fee, and you pay the fee by a Form 720. Now, the problem with the Form 720, it's very confusing because they stuck it in a form that doesn't really apply. It applies for probably 15 or 20 different situations, but they stuck it in there to pay the fee. It's only due once a year. The return must be filed each year by July 31st of the calendar year. And at first, the fee was $1. Then it's going up to $2, and it's going to go up in future years. And it's based on the average number of covered lives. So again, if you're insured, the insurance company will pay the fee. If you're self-insured, you have to pay the fee and make sure you file the return. Another fee is the reinsurance fees. Under ACA, each state is required to establish a transitional reinsurance program. Basically, it's to create a slush fund for insurance companies to engage and be in the exchanges. The program is funded through reinsurance assessment on all insurance carriers and self-insured plans. The collected fee is to support reinsurance payments to carriers that cover high-cost individuals in non-grandfathered plans. So basically, it's a way of enticing insurance companies to participate in the marketplace. For self-insured plans, they are subject to it. For self-insured, employers can use either a TPA or a contractor to transfer the fees, exempt certain self-insured or self-administered plans for making this. A self-insured insurance plan will make reinsurance contributions for major medical. There's certain exceptions. For this purpose, HSAs, health FSAs, expatriate health plans, and prescription drug plans are excluded. Now, for fully insured plans, the insurance companies will pay, again, the fee and pass the cost on to you. The fee for 2014 was $63. This year is $44. HHS will collect all contributions and allocate reinsurance payments on a national basis. The same contribution rate applies to self-insured plans, though these plans are excluded from receiving reinsurance payments. Contributions are paid in 2 installments. Basically, what you had to do was you had to, again, register with the HHS, and then they would tell you exactly when to pay the fees. The other fee is the health insurance industry fee. This is purely an insurance company fee. This is one reason why you may want to go self-insured, because self-insured plans are not subject to this fee. Health reform imposes an annual fee on insurers beginning in 2014. It's going to collect in 2014 $8 billion. It will increase to $14.3 billion by 2018. The fee only applies to fully insured plans. Again, self-insured plans are exempt. Each insurance company will pay the fee by September 30th of each year. Well, the fee will have impact on fully insured plans. Yes, the insurance company will pay the fee and, of course, pass on the cost to employers. So again, this is another fee you're going to see in your bill. How is the fee determined? The fee is determined based on representative market share. What types of coverages are due for this fee? The fee applies to most insurance coverage, including dental and vision plans. Self-insured plans, accident, disability, specified disease and illness programs, and long-term programs are not subject to the fee. So again, all small employers are subject to this fee. Also, another requirement that applies is 90-day waiting period. The 90-day waiting period was effective in 2014. It only applies to, again, full-time employees. As an employer, this only applies to health plan. It doesn't apply, again, to vision and dental plans. If you're a grandfathered plan, you still have to, again, adhere to this rule. And what the IRS said last year, what you can do, you can impose a 30-day orientation period before the 90-day period starts. So in some situations, employees can wait as much as close to 120 days to be eligible to be covered under your plan. So a waiting period, the period must pass before coverage for an employee or dependent is otherwise eligible. The cumulative service requirement applies generally to part-time employees, how many hours they have to, again, accrue to do this. You count all days. Now here's a couple examples. A group health plan provides full-time employees are eligible for coverage. Bill starts his employment by January 19th. He has to be eligible by April 19th, assuming February has 28 days. Another exception is that if you, as an employer, have specified training or certifications that somebody has to complete in order to be eligible, you can do this. Lisa was hired on May 3rd, meets the eligibility requirements on September 22nd. The 90-day period is off of when she completes the requirement, which is September 22nd. So she would be eligible for coverage on December 21st. Again, if an employer provides before a year of service requirement to get coverage, as soon as the 90-day requirement applies, that requirement goes away. A very common question I get is example 4. Example 4 is a calendar year plan. Prior to January 2014, they imposed a 6-month waiting period. Now, this person was employed by October 1st, 2013. At the time she started employment, the requirement was 6 months. As soon as the 2014 year comes into play, this was a calendar year plan, the 6-month period goes away, and now the 90-day period goes away. In this situation, Sarah, at the time of January 2014, had 93 days, so therefore she has to, again, be offered coverage, because at that time, as soon as the 2014 year clips in, that requirement changes to 90 days. Pre-existing conditions, as you all know, pre-existing condition goes away. So this was starting in the 2014 year. This applies to even to small employers. So insurance companies cannot impose a pre-existing condition. Now, what I've been telling my clients to do, especially with the certificate of credible coverage, I would continue to provide for that, even though this requirement is applicable in 2014. It's for plan years beginning in 2014. So if you had an employer with a year beginning in December, they could impose a pre-existing condition up until December of 2014. So I was telling my clients to keep on giving a certificate of credible coverage until the end of 2014, because there could be some employers that still could impose it later in 2014. Out-of-pocket limits, there's a requirement now, this applies to all plans except grandfather plans, that the out-of-pocket limits, that there's a combination of deductibles, copays, coinsurance. For 2014 was $6,350 and $12,700. For 2015, it increases to $6,600 and $13,200. This limit does not apply to grandfather plans. Now, just being made aware, this limit is different than the limit for HSAs. HSAs have a different limit. I think for HSAs it's $6,450, and I think it's $12,900. So if, for example, as an employer, you have this limit for your plan, your employees could not participate in an HSA. It's too high. So again, why they decided to do this, I don't know. But again, for a ACA compliant plan, this is the out-of-pocket limit. Wellness programs. Wellness programs are becoming very popular. All the time people are asking me about wellness programs. And as part of ACA, this has happened in 2014. This applies to all employers. The incentive limit increases from 20% to 30% of the total cost of coverage. Now, what does that mean? The total cost of coverage, basically, if the employee is only eligible to participate in this situation, it's 30% of the single premium. So if you're going to do a wellness program where people have to, again, complete a health assessment and also achieve certain goals, it can be as high as 30% of the single premium. If you're having smoking cessation programs, that smoking cessation program, the benefit under a smoking cessation program can be as high as 50% of the single premium. Now, if you want to encourage the whole family to participate, then you can use the family premium to do so. But again, this is something, again, part of healthcare reform. These rules apply to all employers. Also, approved clinical trials. This applies to small employers. It doesn't apply to grandfather plans. And basically, what the government's saying is we're sick of sponsoring clinical trials, and now insurance companies, if a provider says that particular patient would benefit from a clinical trial, you, Mr. Employer, must, again, cover, starting in 2014, clinical trials. So a group health plan may not deny any qualified individual the right to participate in the clinical trial, deny a limit or impose additional conditions on coverage, and may not discriminate against any qualified individual who participates in a clinical trial. Now, one of the biggest changes just recently was on cafeteria plans and HRAs. The IRS has come out with a lot of guidance recently in regard to this. In Notice 2013-54, it prohibits reimbursement premiums for individual medical policies from health reimbursement arrangements and premium-only plans. Basically, what many small employers were doing is that they couldn't afford group health plans. So what they were doing is they were saying, employees, bring us your individual premiums, and we're going to reimburse it under an HRA or a POP plan, and we can do it pre-tax. And many times with HRAs, they would also reimburse unreimbursed expenses. This was somewhat common in the small plan market. But 2013-54 said, sorry, you can't do it anymore starting in 2014. It is not possible to do that. Now, what you can do, you can reimburse premiums for other types of individual coverage, dental, vision, and especially under POP plans, you can do, for example, AFLAC policies, supplemental policies, no problem. But you cannot reimburse individual premiums. It is prohibited to do so because that is a violation of ACA. And these rules were effective for plan years beginning in 2014. Now, on February 18th, 2015, the IRS released Notice 2015-17. And what they said, okay, we're being a little harsh. And what we're going to do, we're going to create special exceptions. But basically we're going to create a special exception for small employers to reimburse individual policies. We're going to allow S-Corps to reimburse health care arrangements. In certain situations, you can reimburse Medicare premiums and also TRICARE premiums. So the IRS will not impose any excise taxes for 2014 up to June 30th, 2015 if you are a small employer and are reimbursing your employees for individual coverage. So employees eligible for relief are excused from any requirement to self-report for violations under Form 8928, because what the IRS has said before, if we audit you and you've been doing this, you could be liable for a $100 a day penalty per employee for this practice. So what they're saying is for any small employer under 50, you can continue this practice until June 30th, 2015. After that, you have to report what you're doing, and if you're in violation, you are going to be subject to the penalty. So they're giving a relief only to small employers. Now, this notice does not apply to standalone HRAs or other arrangements to reimburse expenses other than individual premiums. Also what they said, and what this slide indicates, if you are an S-Corp corporation, you are reimbursing shareholders for individual policies, what they're going to do pending issuance of additional guidance on these arrangements. The notice provides that an S-Corp will not be subject to any penalties for having a shareholder reimburse employees, 2% shareholders, for their expenses. Also what they indicated, for Medicare, the notice permits an employer reimbursement of Medicare Part B and D premiums to be integrated with another group health plan, but only if the employer offers a group health plan, the employee participates in a premium reimbursement, is actually enrolled in Medicare's Part A and B. Premium reimbursement is available only to employees who are enrolled in Parts A and B, and the reimbursement is limited to Medicare Parts B and D. Now, what they want in this situation is, remember, there's Medicare secondary payer rules. If you're an employer 20 or more, if you do this, you're in violation of the Medicare secondary payer rules. So this only applies to smaller employers. So you can reimburse employees for these premiums. So the notice confirms an employer may increase an employee's taxable income not conditioned on the purchase of health insurance. What this is trying to say is if you're an employer, you're a small employer, and you want to give money to the employees to reimburse premiums, you can do so, but you have to do it. One, it's got to be taxable. That's what this slide says. And two, what you have to do is that you can't make it condition on buying insurance. It must be, here's $200 a month. We don't care if you buy any insurance at all. But here's $200 a month. What this slide is trying to say is, in fact, you can do that, Mr. Employer, but it must be taxable, and it cannot be conditioned on buying insurance. Now, freestanding HRAs. What some employers were doing in the past, especially small employers, as I said before, is having freestanding HRAs. Basically, what Notice 2013-54 said, if you're going to have a HRA, it must be integrated with a group health plan from the employer or from another employer. The rules will vary depending on the group health plan as minimum value. And again, you can still have a freestanding HRA to reimburse premiums or expenses for dental, vision, those type of expenses. And you can also have a freestanding HRA for retiree. That's very common. Also, health FSAs. If you're sponsoring a health FSA, if a health FSA is what's called an exempted benefit, it's not subject to health care reform. Now, freestanding HSAs are still possible if you're only reimbursing dental and vision. So what are the requirements for an exempted benefit? In that situation, when an exempted benefit is, the HRA must again have employer contributions that don't exceed $500, and it must be offered with a group health plan. If you comply with that, that's an exempted HRA, and therefore it's not subject to health care reform. Now you may ask, well, what's the big deal? Suppose my health FSA is subject to health care reform. What does that mean? It means that you must offer unlimited preventive care, and you want to avoid that. All right? Now, another development under health FSAs is the fact that you, as an employer, if you sponsor a health FSA, you can allow up to $500 to be carried over until the next year. Some employers are doing this. It's been effective for 2014 and later. You can carry over, it can be allowed to be used for all or the next plan year, but there's still many unanswered questions. For example, we don't know how we're going to determine the COBRA premium on this carryover. But you as an employer, you don't have to do this. The cafeteria plan must be amended to allow it. But what you can do if you're going to, again, have a health FSA and want to do this, you can give the employees the option to whether to carry over or not, and whether that carryover is going to be a general purpose or a limited purpose. So it can be very flexible. But again, I'm surprised, this is not as popular as I thought it would be. Now, again, participation in a cafeteria plan. A big question has come up. If you sponsor a cafeteria plan, either a premium-only plan or a health FSA, and the questions come up, well, suppose my employee wants to go in the exchange. And remember, when you're under a cafeteria plan, either a POP plan or under a health FSA, only under certain conditions can you allow that employee to drop coverage. And generally, employees were, if they wanted to go on the exchange up until now, they were prohibited to drop coverage under a cafeteria plan and then go on the exchange. Well, the IRS said, we're going to change that. And what they indicated is that if you have an employee whose hours are reduced so the employee is expected to average less than 30 hours, but the reduction does not affect their eligibility, you can allow them to drop coverage. Secondly, if you want to do this, you can allow if an employee either under annual enrollment or special enrollment enrolls in the marketplace, you can allow your employee to drop coverage if you want to do this. Now again, this is not required. You can do this if you want, but it's not required. And I'm warning employers in this situation, it could, if you allow an employee to go on the exchange and drop coverage, either at open enrollment in the fall or special enrollment, it could blow apart your participation in your group health plan. So you've got to be real careful how flexible you're going to be. All right, any questions so far? Insurance mandates. The insurance mandates are really hitting small employers. Transitional rule in November 2013, CMS announced a one-year transitional rule allowing insurers and in the individual and small plan markets to renew health insurance policy that would otherwise be canceled due to non-compliance with certain insurance rules. In March 2013, IRS announced a 2-year extension of this policy, indicating they will consider the impact for the 2-year extension for transitional policy in assessing whether the additional 1-year extension is appropriate. Under this transitional rule, individual and small group policies that were renewed for the policy year starting between January and October 2014 will not be considered to be out of compliance with 6 specific reforms, including premium rating rules, guaranteed availability, renewability, and the required to provide essential health benefits, and provided that certain conditions are met. These policies are considered to be minimal essential coverage, even though they do not comply with certain aspects of health care reform. What the last statement means is, even though this policy technically is not subject to or not compliant with health care reform, if you continue these policies, your employees won't be penalized for the individual mandate. So for the next 2 years, you can have it, and your employees won't be penalized. So they realize they overstepped, and they're creating a 2-year window. Now, guaranteed availability. Each insurance carrier that offers health coverage in the individual and group market is required to accept every employer and individual that the state applies for such coverage. Enrollment may be restricted to open and special enrollments. And insurers in the small group market apply minimum participation rules other than during the annual enrollment period between November 15th and December 15th. Now, to the extent permitted under state law, an insurer can discontinue products in the small group market, and renewing the product, the insurers in the small group market must provide each plan sponsor a written notice of renewal at least 60 days before the renewal. An insurer may refuse to renew a group product for certain specified exceptions. These include non-payment of premiums, fraud, material misrepresentation, the employer's failure to meet minimum contribution and participation requirements, the insurer's discontinuance of a particular product, or all coverage in the market, or no enrollees in service area, and uniform modifications. Now, what does this mean? It means insurance companies can, again, have to accept you, but they don't have to renew you. That's what this is trying to say. So you're going to see in the small plan market, especially when employers are struggling in certain industries because the employees can't afford the coverage, they're going to be bouncing from insurance company to insurance company almost every year because of these rules. And I talked to a lot of people in the fast food industry, in various hotels and other industries that have a hard time offering insurance because they can't meet the participation rules. And the insurance companies can still impose those rules. I have a number of situations where an employer said, I want to offer coverage, but I can't get enough employees because they earn too little. They can't afford the coverage. So it's a really strong dilemma for many small employers that have a lot of lower paid people. They can't offer coverage. They have a really tough time. So that's why some employers in the small plan market have decided to drop coverage because they can't afford it. Their employees can't afford it. That's a huge problem. So an insurance company can refuse to renew a group policy if the plan sponsor fails to comply with material plan provisions relating to the employer contribution, group participation rules pursuant to state law. For this purpose, an employer contribution rule means a requirement relating to minimum level and amount of employer contributions. Now, what are for example, Blue Cross, doesn't Blue Cross require that employers pay at least 50% of the premium? The term group participation rules requirement relating to the minimum number of participants or beneficiaries that must be enrolled in relation to specified percentage and the number of eligible individuals. Now, Bill, Blue Cross Blue Shield, what is the participation rate that they require?
At this point, when we check, it's usually they want to have 25%. They hope 50%.
Now, if your plan has not been protected and you are a small employer, these are the factors. This is the fair insurance premium rule, and for the individual small plan market. Premiums charged by insurers in the individual small plan market may vary with respect to particular plan of coverage only if the coverage is individual family, rating area, age, and tobacco use. These are the only factors they will use if your plan is non-grandfathered. So these are the only factors they will use to determine. So basically what this is trying to say is that your experience doesn't matter anymore. It's basically these factors. So if you're a company that has a lot of younger people, you may see significant increases because this factor right here is extremely important. The age. The rate cannot vary by more than a factor of 3 to 1 between the oldest worker and the youngest worker. Now, Bill, what was the rule before? Wasn't it a 10 to 1 or? Okay. Then what was it? Was it 8 or 9 to 1 before? 9 to 1. So therefore, because of healthcare reform, now the younger workers are going to be paying more. So if you have a lot of young people working for your firm, that's a problem. So for effective for plan years beginning on or after January 1st, 2014, health coverage offering coverage in the individual small plan market must cover essential health benefits. This only applies to medical plans. So to provide essential health benefits, they must provide essential health benefits, limit cost sharing, and provide either a bronze, silver, gold, or platinum. This relates to 60, 70, or 80 or 90% of full actuarial value. Now, here's a dilemma. If you're an employer that is in the small plan market, and you offer, for example, one of these plans, gold, silver, gold, or platinum, and you offer a HRA with it because you want to reduce the deductibles. The problem is going to be in the future, and some insurance companies are enforcing this. If it blows past these 60, 70, 80, or 90% limits, and it's like 75 or 85%, technically that plan is in violation. Because the differential in the 60, 70, 80, and 90% is 2 percentage points. So again, be very careful in regard to this. Now, this is the definition of essential health benefits. In the small and the individual plan markets, your plan has to cover all these different factors. And that's the reason why, in this situation, premiums have gone up. You have to cover all these different factors. Now, cost-sharing limits. Health plan requires cost-sharing. Again, I've covered deductibles, co-pays, co-insurance. Now, before, there was a limit on annual deductibles. Okay? And before, there was a $2,000, $4,000 in the small plan market. But Congress realized, because the insurance companies were telling the Congress that we cannot get down to this level in a bronze plan. It's impossible to get to this level. So what they said in Section 213, the Protecting Access to Medicare, they actually, in 2014, they repealed this requirement. So again, sections of healthcare reform have been repealed. Now, I'm just going to just slide through this very quickly. What employers are eligible for the marketplace? So beginning in 2014, small employers are eligible to go on the marketplace. A small employer is any employer employed an average at least 100. Illinois has picked 50. So before 2016, a state will have the option to define a small employer by substituting 50 for the standard definition. And what you can do is go on the small business health option or SHOP option. Now, the problem with the SHOP option, and again, I'm going to breeze through this. You can read this later. In 2014, the problem with the SHOP option was that it wasn't up and running. And basically what you had to do was submit a paper application. That was the problem with it. So for 2014, small employers enrolling in the SHOP option in some state-based exchange must use a direct enrollment process, submitting a paper application rather than applying online. And most employers will work with an agent, broker, or insurer. And HHS has announced for the first time, starting in November of 2015, small employers will be able to enroll online for the first time. So it won't be up and running until November 15th, 2015. So again, if you're going to participate on the SHOP, it's going to be through paper until that date. So again, direct access will cease to be an option as of November 15, 2014, when the employers wanting 2015 coverage in the SHOP must use the online service. Again, the SHOP will offer various functions. Starting in 2017, an exchange may choose to allow insurers in the large plan market, which means up to 100. Different structures will be established for state-based versus federal-based. And one thing is very important in the SHOP, they'll have an employee choice option where you can go in and pick coverages in various insurance companies. This will be available in the SHOP. Okay, let's skip a couple here. There's going to be a premium calculator to help employees determine the cost of coverage. Let's skip this one. Illinois has a federally facilitated SHOP are expected to provide a number of tools and resources to help employers, employees, and agents broker coverage options. This will allow employers to model scenarios. Federally facilitated exchanges will collect one single aggregated payment for each employer. Federal SHOP are expected to offer additional administrative support, including employer billing, receipt of payments and disbursements, and multi-state employers participating in federally facilitated SHOP will offer coverage for all eligible employees. Okay, let's skip this one. Now, employers eligible with SHOP. A SHOP must permit qualified employers to purchase coverage on the SHOP. If you're a small employer, if you elect to offer minimum coverage for all full-time employees, and either have a principal office in the exchange area or offer its employees coverage. A small employer, again, is 50. SHOP must permit a qualified employer to purchase coverage any point of the year. The employer's plan year must consist of a 12-month period, and the SHOP must provide qualified employers with a period of no less than 30 days to complete an annual enrollment. Qualified employers in the SHOP with information about individuals whose eligibility to purchase coverage. And then SHOPs must allow qualified individuals to enroll in the SHOP and change from one to another. These are the special enrollment events. If you lose coverage, if you gain a dependent, if your enrollment is unintentional, an enrollee accurately demonstrates to the exchange that he or she is enrolled and substantially violated, you gain, again, a permanent move. So, again, during the year, you can enroll in the SHOP. Employer contributions must elect various ways to contribute. You can do a POP plan under a SHOP. And now, in 2014, there's also, for the small employers, a tax credit. It's a tax credit up to 50% of the premiums. This is, again, for small employers for 25 or under. For non-elective contributions in 2014 and later, tax years, there must be on behalf of employees who enroll in a qualified health plan through the exchange. So you must, in order to get this, you must go through the exchange. In order to qualify to receive a small business tax credit up to 50%, you must be, again, a small employer. And this is the definition of a small employer. You must have no more than 25 full-time employees, and your average annual wages does not exceed $50,000. Now, because of this, I've talked to many accountants. Very few employers ever qualify for this particular credit. Now, reporting. If you're a small employer under 50 and you are insured, the insurance company will give your employees a form called a 1095B. So please remember that. Employers who are not subject to the employer mandate, insurance companies, and also self-employed, self-insured, and multi-employer plans that are small, if you're a self-insured employer under 50, you'll file a Form 1095B. Now, the way you determine whether you're a large or small employer, for 2015, it's an average over 2014. Basically, what you do, you count all hours for 2014 for each month. You take the totals for each month, and you count all hours. For this purpose, a full-time employee is anyone who works 120 hours or more. If somebody works less than 120 hours, you again add up all the part-time employee hours, divide by 120, add the two figures together for each month, and then you can do it for 2014 either over the calendar year or any consecutive 6-month period. If you're under 50 and you're insured, the insurance company will do this for you. If you're under 50 and you're self-insured, you have to give the employees a 1095B by the end of January 2016 and then file with the IRS. The purpose behind this form is to tell for the individual mandate which employees were covered by your plan. That's the purpose behind the 1095B. Now, along with the 1095B, there's a single transmittal form called a 1094B. That's filed with the IRS either by the end, it's filed by the IRS by the end of February of 2016. So the form is generally filed with the IRS by February 28th, March 31st if doing electronically. And again, it pertains to the previous calendar year, what coverage you offered and who took it in 2015. Now, if for some reason you've discovered you become 50 or more, all right, then starting in 2015, you have to file a 1095C. And the purpose of the 1095C is to report what coverage you offer to your employees. Was that coverage affordable? Was that coverage minimum value? And who you offered coverage to? So under the 1095C, there's two sections. One section talks about who you are, the second, or who the employee is. The second section talks about what coverage you offer to the employees. And the third section is what coverage, whether that individual is covered. That is only completed if you're self-insured. The 1095C is extremely complicated, and it's going to be due for 2015, filed in 2016. So what you're reporting basically is what coverage you offer to your employees in 2015. And the IRS will do this, will take that information, you're 50 or more, and determine whether you're going to be liable for an employer mandate penalty, and they will also determine if the employees are going to be eligible for any credits or subsidies. That's the purpose behind this form. Now, to complete this form, I tell people it will take a village to complete it. It's going to take your accountant, your attorney, your broker, because each one of those will have information in order to complete this. So please be ready for this and start collecting information in order to file this form. But again, you only have this obligation if you're 50 or more full-time and full-time equivalent employees in 2014 for 2015. All right? Are there any questions? Am I on time?